At this time, I would like to call this meeting to order. Good evening, everyone. Today is Wednesday, December 14th, 2022, and this is a special meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. I would like to ask everyone to follow me in the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Ms. Secretary, may we have a roll call?
Commissioner Kirpies?
Here.
Commissioner Maggio? Here. Commissioner Martz?
Here.
Commissioner Montemayor will be absent for tonight. Commissioner Wright will be absent as well. Vice Chair Ayers? Here. Chair Topshin?
Here. We have a quorum. Thank you. All right, next is approval of agenda. Has the Commissioner had a chance to review the items before us tonight? Anyone would like to make a motion?
Motion to approve.
I'll second.
All right, we have a motion to approve. And the second, Ms. Secretary, may we have a roll call vote?
Commissioner Kirpies?
Aye.
Commissioner Maggio?
Aye.
Commissioner Martz?
Aye.
Vice Chair Ayers?
Aye.
Chair Topshin?
Aye. Motion carries. Thank you. Next is approval of minutes for the meeting on November 10th, I believe. Yeah, November 10th, 2022. Has anyone had a chance to review the minutes?
Motion to approve.
I'll second.
Okay, we have a motion to approve the minutes. And the second, Ms. Secretary, may we have a roll call vote?
Commissioner Kirpies?
Aye.
Commissioner Maggio?
Aye.
Commissioner Martz?
Aye.
Vice Chair Ayers?
Aye.
Chair Topshin?
Aye. Minutes are approved. Thank you. Next is public comments. Ms. Secretary, do we have any speakers that are not going to speak at the appeal?
Not at this moment. We only have the appeal parties in the wait room.
All right. So we don't have any speakers. Next will be the manager's report. The rent stabilization manager, Mr. Jonathan Hollop, this is your time.
Thank you, Chair, Vice Chair. Good evening, Commission. Jonathan Hollop, Rent Stabilization Manager. Tonight, you'll be hearing an appeal of a rent increase case, I-152. The meeting for December 22nd is canceled, and then an appeal will be heard at the January 12th meeting. I know it looks a little light going forward, but you don't have any other appeals at the moment. I'm sure we'll get some, but staff will be bringing items in the new year, and we'll have other things for you for sure in 2023. I also wanted to let you know that I don't actually have a current update on BetZedek's eviction caseload. I'm waiting for those numbers. I'm sure in January I'll have the most recent numbers for that. The county's tenant protection resolution is set to expire on December 31st. Most importantly, that means that tenants, regardless of their income and impacts by COVID, will be required to pay rent starting on January 1st. Links to information about rental assistance can be accessed by going to WehoTV.org and typing financial assistance into the search bar, or by contacting the City Social Services Division at 323-848-6510. Commissioner Kirpies, you had recently inquired about the progress of the city's mandatory seismic retrofitting program. A significant amount of progress has been made, and details regarding that progress and specific property status can be found at the city's open data portal, and that's at WehoTV.org under the City Government tab. And then once you click on that, you go to All Data, and all the data for that particular project is there, and it's consistently updated by our Building and Safety Division. If you want additional information, you can go to WehoTV.org and type in seismic in the search bar, and that will direct you to a site with all the relevant information about the seismic retrofit program. The rental registry will be expanding to include non-rent stabilized properties in the new year. Staff is currently working with the registry database vendor to update the system. And as I mentioned at the last meeting, a preliminary letter was mailed to property owners alerting them to the coming change. Staff and the vendor are working toward the launch of the registry by late winter, and will follow up with detailed registration instructions when that system goes live. Landlords may begin taking the annual general adjustment again on March 1st of 2023. The rent adjustment for the period March 1 through August 31, 2023 will be the recently adopted cap of 3%. A mailer with this information, along with RSO compliant rent increase notices and a form for providing or demanding the annual interest on security deposits, will be going out to the rent-stabilized landlord and tenants in the city before the end of the month. That's all I have, and I'm available for any questions.
Okay. Do the commissioners have any questions regarding the report? Thank you. Commissioner Kurpis.
I just have one question, and then say thank you also for the update on the seismic retrofitting. But the question I have about the interest rates or interest earned for deposits, when does the tenant have until to claim that or to accept that?
Well, they can claim it any time, but they're entitled to it no later than February 1st.
Other commissioners? Ms. Manager, since you mentioned that beginning January 1st of next year, the tenants will be required to pay the rent. With that, what would be I know you mentioned before at one of our meetings, but what are the protections if the tenants are unable to pay rent because the COVID reasons, let's say, still exist? And the other part of the question, what happens to the amount that the unpaid balance they accrued during the pandemic or the emergency?
Well, on the first, there will no longer be any protection. So if you're not able to pay your rent, and even whether you're impacted by COVID or not, you have to try and pay your rent because there's no protections. And as I mentioned, there is some limited rental assistance available through city partnerships, and I would encourage people to visit our social services division page or to call social services division to try to get directed to those providers. Regarding debt up through the end of the year, that is consumer debt that the tenant has to pay, doesn't have to pay for 12 months, and then it would have to be collected through a judgment or some other arrangement between the landlord and the tenant, but they do have 12 months from the end of the protection period until the end of the following 2023 to pay that consumer debt.
So can a landlord initiate an unlawful detainer process based on that rental debt?
Well, the thing is that a landlord can initiate an unlawful detainer process, full stop.
Okay.
These are all affirmative defenses. So, although you would hope that if it's clear that a tenant has given a legitimate reason up until December 31st for not paying their rent, that a landlord wouldn't bring a UD, and hopefully they would be unsuccessful if they did, they can still actually do it, and the tenant would then have to raise that affirmative defense. This is a good opportunity to remind tenants in the city of West Hollywood that the city does provide, is in a contract with Betzetic Legal Services, I mentioned, to provide free representation if you are facing eviction. And if anyone gets a notice or gets served with an unlawful detainer complaint, they should contact the Rent Stabilization Division, and we can point them to Betzetic Legal Services. But in any case, the protection would exist for those tenants who made a good faith claim of the inability to pay rent from during the COVID period up through the end of the year. So at the end of the day, you hope that landlords who have a tenant who's made that claim legitimately aren't going to try to bring a UD, but they might. And in that case, they should just raise the defense.
Okay.
Yeah.
And I believe this information is available to the landlords and tenants. And is it a bulletin that the department sends out, or what are the resources?
Well, we've sent out newsletters that contain the information about Betzedek, about the where to go to find out what's going on with the tenant protection resolution for the county, and it is on our website. Currently, there's a table that the county has produced that's on our website. So there's plenty of information out there for tenants who are, and landlords who are looking for information about what's an appropriate claim of hardship up and through the end of the year and what's not going to be.
All right. Thank you, Mr. Manager. Thank you. If no more questions, so we're going to move on to the Commissioner comments, which is the next item. Commissioner Martz.
Yes, I just wanted to extend my congratulations to everyone who was elected and all those who ran if they didn't make it this time. We have some exciting candidates taking office, and it was an exciting race, and it was fun to be part of it. And so congratulations to everyone that's new, especially those who are new or returning council members in the city of West Hollywood.
Thank you. Commissioner Marger.
I just wanted to report that I did attend the Business License Commission as the liaison from our commission, but I do not have a report. I was there mostly to observe, and they're doing very good work. Thank you.
Thank you, Commissioner. Other comments? Vice Chair, please.
I just want to mention that on Monday, I did attend the city's AB 1234 training, otherwise known as the ethics training, which is also available to complete online. And I mentioned this only to just be I guess, open with the public that this is something that the city takes seriously, and they have a very thorough program to make sure all city employees, elected officials and appointed officials do take this training and complete it and get their certificate for completion. And I know everyone on this board will be doing the same. Thank you.
Added note that if you do it online, you have till December the 31st.
Great. Thank you, Commissioners. All right. Moving on to the next item on our agenda, which is the appeal section. And we have one appeal before us this evening, and that is a rent increase based on net operating income application I-152R, which pertains to the property address 1021 North Edinburgh Avenue. And this appeal is filed by the tenants. Ms. Secretary, can we confirm if we have all parties present, the tenants and the landlord or their representatives?
We have 3 tenants present via Zoom, and we have 1 tenant present in person.
Okay. All right, and everybody is connected and they can hear us or they can see us.
Yes.
Okay, good. And what about the landlord?
Landlord is also present.
It's via Zoom?
Yes, via Zoom.
Okay, thank you. All right, so before we begin, I'd like to take a moment and explain the appeal process. First, we will hear a staff report presented by the legal counsel, Mr. John Natalizio. And then following that report, there will be oral argument during which the parties may present their case. Since the appellant in this case are the tenants from units 1, 2, 5, 6, 7, and 8, they will speak first. So what we'll do is we'll allow each tenant to have a full 5-minute segment to present their case, their position. The respondent, that would be the landlord in this case, will speak second, and the landlord also will have a full 5-minute segment to present their case on the appeal subject. When it's time for you to speak, please state your name and the city of residence for the record and proceed with your comments. Since your speaking time is limited, it is important to keep the following in mind. Keep your comments on the topic. The only information you want to share tonight is the information about your appeal. New evidence cannot be considered received by this commission. You may only discuss issues that were raised at the hearing or evidence submitted to the hearing examiner. If you go off topic, you may be interrupted. All right. So with that said, Mr. Natalizio, we're ready for your report.
Thank you, Chair. Good evening, Chair, Vice Chair, and Commissioners. My name is John Natalizio. I am the legal counsel to the Rent Stabilization Commission for the city. This appeal follows a remand hearing. This appeal was filed by the tenants for units 1, 2, 5, 6, 7, and 8 of a property located at 1021 North Edinburgh Ave in response to the hearing examiner's remand decision granting the landlord's net operating income, which I'll refer to as NOI, rent increase application. As due to the complexity of the issue at hand, I'll generally defer to the staff report and the appeal packet, which provides a more substantive discussion on the appeal and the underlying issues of the case. The general premise, however, is that the landlord's NOI application sought a fair rate of return in order to provide a just and reasonable return for owning the property. In order to determine the fair NOI, the Rent Stabilization Ordinance sets forth a procedure for its calculation, which is also detailed in the staff report. During the original appeal hearing on this application, the Commission found that the hearing examiner had erred and that there was not substantial evidence supporting the hearing examiner's decision, and the Commission remanded the case back to the hearing examiner with detailed and clear instructions. Staff believes that the hearing examiner's remand decision is also not supported by substantial evidence and that the hearing examiner erred. Staff finds that despite landlords' failed attempts to establish a fair NOI, the evidence in the record does support that landlord is not receiving a just and reasonable return based on the rents. However, considering a fair NOI calculation that is just based upon the rents requires that the Commission modify the formula, which they do have statutory authority to do under the Rent Stabilization Ordinance's Savings Clause. Staff's recommended action is set forth in detail in the staff report, but summarily requests that the Commission set the base year as 1983, since the rents can be reliably established for both the base year and the current year. However, the Commission will modify the fair NOI formula to not consider operating expenses as part of the NOI calculation. Since landlord is unable to reliably establish operating expenses for 1983, then it is unreasonable and fundamentally inequitable to consider the current year operating expenses. Therefore, the NOI will simply be the gross income, again, which has been established as just the rents. And staff will defer to the staff report for the detailed calculation of the fair NOI and the unit's maximum allowable rents based upon this calculation. Therefore, staff recommends adopting Resolution RSC 22-620. You as the Commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the Commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. And as it relates to questions of law, the Commission applies an independent or de novo standard of review. Thank you.
Thank you. Commissioner Kurpis.
Yes, I have a question about, so I understand how staff has explained that the Commission has the authority to change the formula, and we would basically be disregarding any calculation, whether past or present, of the current operating expenses. And we're choosing the 1983 year because that's the evidence that the landlord had previously supplied, right? And it shows for all 8 units, what the rent was. If we were to have or if they chose a different year, let's say 1995 or 89, and happened to have all the evidence for those years, could the calculation be different from that CPI rating to present, or would the CPI would the outcome only be different if we went before 1983? 1983, and looked at CPIs prior to that.
Okay, so I'll just answer as I can, and you let me know if I missed something. So the first part, the reason why 1983 is the base year in this situation is because that's one, the code presumes 1983 is the base year. However, it does permit a different base year if there's essentially good cause. And here, the commission during the original appeal hearing, remanded it back to the hearing examiner and allowed the landlord to either submit further evidence supporting 1983 or choosing an alternate as the base year. And in this case, the landlord did not choose an alternative base year and continued to pursue 1983 as the base year. So to that effect, the only evidence at all in the record relating to a base year is 1983. So that's, I think, the first answer to your question. And then the second part is, yes, if the landlord chose a different base year and the landlord was able to reliably and sufficiently establish operating expenses for that base year, then presumably there would be no reason to modify the formula, and then the commission would just use the formula looking at both the income and operating expenses.
I guess my question really has to do with us arbitrarily choosing to, the tenants have not had an opportunity to present, let's say if 1995, just to choose a year, were chosen under the formula that you're suggesting we use tonight, where we disregard operating expenses and just look at rents and CPI difference, would the calculation possibly be different that may benefit the tenant or may benefit the landlord if a different year had been chosen? And if it did, then I would suggest that it would be unfair for us to move forward tonight because the tenants wouldn't have had an opportunity to provide a different year with all the evidence that they would need to show the rents for that if it benefited them. But I just don't know how the calculation works out if you take those CPIs.
Yes, I think, if you choose a different base year, it fundamentally will change the outcome of the formula. So, presumably, as you move up in time, that difference between the base year and the current year presumably would decrease because presumably rents increase every year and operating expenses change. So I couldn't speak to how it would change it, but yes, it would fundamentally change the outcome of the formula. But my legal advice would be is that there's nothing in the record at all that would support a base year other than 1983 under the proposed solution, simply because there's no evidence in the record at all about a base year.
Yeah, and I guess
so
my
you
question
couldn't
is,
choose like 1995. There wouldn't be anything in the record to support that.
so I understand that the evidence does not exist, but could it be that the evidence doesn't exist because there was never the tenants weren't offered an alternative, nor was the landlord. This is something that staff has put in front of us this evening for tonight's consideration, but neither party would be able to present evidence that would support a different year based upon this new formula that you're suggesting that we use.
Well, no, I think that no, because the base year that I'm using is the base year the landlord wanted, which is 1983. So staff isn't recommending a different base year, and I think that both the landlord and tenants have had opportunities to not only provide all the evidence they want to support 1983 as a base year, but as well as a different base year, which was the whole purpose of the remand hearing, which was to give the landlord the opportunity to either bolster his position that 1983 is the base year, or if he couldn't find the evidence necessary to support 1983, choose a different year. And the landlord didn't submit any additional evidence. And so that's why in staff's recommended action, we're using 1983 because that's the only thing in the record.
So am I correct in saying that we're finding a solution for the landlord? I mean, there doesn't seem to be any evidence that addresses the issues that we as a commission already said were important and needed to be resolved. And there seemed to be little, if any, attempt to do that.
From staff or the hearing examiner?
Well, yeah, either. I mean,
Either.
I wouldn't say the hearing examiner didn't try. I mean, they definitely tried because they tried to find different ways around it. But is it our responsibility to solve this problem for the landlord? Because that's what I feel like we're being asked to do.
Well, it's the commission's responsibility to make sure that the RSO is followed and that there's a provision in the RSO that's referred to as the savings clause. And what the savings clause says is that a landlord must receive a just and reasonable return. And this is a bigger issue, a bigger legal issue, which is rent stabilization can only exist if a landlord receives a just and reasonable return. And what the RSO says is that this fair NOI formula is how the landlord is ensured it receives a just and reasonable return. And so the commission is granted the power to modify that fair NOI formula to ensure that a landlord receives a just and reasonable return. So at least to answer your question, are we doing the work for the landlord? I mean, I think that's an argument. I think you could arguably see it that way, particularly, especially if you're the tenant. But I think that this was staff's attempt to comply with that RSO savings clause provision in recognizing that, I mean, I think it's objective that the rents at this property are fundamentally low, and that if you just look at the rents, that the landlord is not receiving a just and reasonable return, and this was staff's attempt to meet that savings clause provision. But I understand what you're saying, and I do think it's an argument.
Other commissioners? Commissioner Maggio, please.
John, one question for clarification. How could we expect the landlord to really have any proof from 1983 if he just recently has purchased the building?
So this was part of the problem at the underlying hearing that the commission faced, which was that the evidence presented by the landlord to support 1983 as the base year was evidence that, for example, would suggest operating expenses. So, for example, I believe that the landlord submitted a bill for like trash services for the adjacent property, and they submitted documents showing what rates were or utility rates were in a different part of LA County. And all of those things, while might suggest ultimately, what operating expenses could have been, they didn't actually show what that building's actual operating expenses were. And the commission found that you could not base operating expenses on evidence that is speculative and doesn't actually reflect the building's operating expenses. And so what the commission said is, the landlord made a good faith attempt to establish 1983 as the base year, but the evidence submitted was insufficient, and to go back and get it. And if you can't get that evidence that accurately reflects 1983, then to choose a different base year in which you can get that documentation. And then the bigger question is what if no documentation exists establishing a base year? Then I think that that leads to a bigger discussion of then this falls on the landlord to prove that he's not receiving a just and reasonable return. And so if he doesn't have the documentation to show that he's not receiving a just and reasonable return, then that's the landlord's problem. And when he purchased this property, if he was not able to get those documents he needed to prove the rents, that's a different issue.
So if he can't prove it now, he probably could prove it in a year, right? Hypothetically, because
If the landlord gets the documents at any time after this, he's free to submit another NOI application trying to establish either 1983 or a different year if he gets that documentation.
Okay, thank you.
Thank you. Ms. Nataliza, sort of a procedural question. For remand hearings, a record will be open for any party to submit any additional information, correct? Any additional evidence?
In this case?
Well, specifically in this case, of course.
Yeah, sorry. Yes, in this case, the remand hearing allowed both the landlord and the tenant to submit any evidence justifying either 1983 as the base year or a different base year.
So both parties, tenants and the landlord, was allowed that time to submit any additional documentation if they had to establish whether it's 1983 or a different year.
That's correct. The remand hearing effectively was a brand new hearing.
Okay. All right. Thank you for confirming that. All right. Since the commissioners don't have any further questions at this time, for you, we're going to move on to the oral argument portion. And I would like to invite, as I said, since the appellant are the tenants, I believe their appeals were filed on September 12th by the tenants from Unit 1, 7, and 8. And I will basically allow them to speak first. And then the tenants from the Units 2, 5, and 6 will speak after that. Again, as a reminder, each tenant will have 5 minutes to address the commission and to present your case. During those 5 minutes, please keep on topic and don't go off the issues that were discussed at the hearing, at the remand hearing. Now, Ms. Secretary, who is in unit number 1?
In unit number 1, we have Miriam, and she is not present in person or in Zoom.
Okay. The next would be unit number 7. Terry.
Yes, and she is present on Zoom.
Terry Bolo, right? So what I'm going to ask you, please, are you connected? Can you hear us? All right. I don't know what's going on. Maybe, is it us or it's the other party? It's probably, if you have two, ma'am, if you have two sources of the phone and the computer at the same time, please lower the volume or turn off the volume for one of the devices.
Terry, do you have us on one device only?
Me?
Yes, do you have us on multiple devices? We would need to only have you on one device, or else it's going to echo. If someone else is in the room, if they can step to a separate room, just because it'll echo on our end.
Okay, just make sure that you're using one device, whether it's your computer or tablet or the phone. All other devices, please turn them off the volume.
Okay, I think we're good.
Okay, perfect. So now, as I said, you will have 5 minutes. Please begin by stating your name and the city of residence for the record, and you will, and you can speak.
Okay, Terry Bolo. I live in West Hollywood. And I've lived in the building for 42 years. And in that time, I had a different landlord when I first moved in. And then Stephen Jarvis and Sonia bought the building from them. And then Stephen passed away, Sonia took over management of the building until the city took it from her because of gross negligence, and she was cited multiple times and fined many times, and she never did raise the rent. She wasn't as good of a business person as her husband, but she also never did anything for the building.
Talk about what Taylor's doing, not about her.
We were on our own, and we would do our own repairs and then deduct them from the rent. She never raised our rent, but she never did anything either. We had raw sewage coming up in the front yard. The 2 units downstairs, which he has kept empty, which is part of the reason he's not making any money, were gutted, were destroyed when the sewage came in through the units, destroyed the floors, and she gutted the whole unit and left them that way. And then the stair rail was rickety, and she tore it down, chopped down our staircase. We were without a staircase for two years. So, you know, she didn't raise the rent, but we were living in very substandard conditions. And so when Taylor bought the building from the city, after they did the minimal code upkeep, then all of a sudden he wants, you know, to get market rent when she didn't raise the rent. So that's what the rent was, and he knew it. It was on the internet. And so for him to try to raise our rent to what would be market now is outrageous, given that the building is in very poor condition, and he doesn't want to do any of the regular maintenance. Anything that's been done in this building in the last 20 years, the tenants have all done it on their own. So, but a couple of the units, the people have been here a long time, so they're in very poor condition and need work. So I don't feel that it's justified to raise my rent $400 or by 40%. Although I do know that whatever the rent is, West Hollywood allows a certain percentage per year, but there's a contract. I mean, the landlord is supposed to do certain things in order to get those increases. So I just think that what he's trying to do is get us out of the building by raising our rents and, you know, to, you know, outrageous amounts. I mean, and if you come and look at this building, you know, and compare it to other places in the neighborhood, it's really in very poor substandard condition. Everything is
making us go through these hearings.
And then everything that we've been put through over the past, like, at least year and a half, maybe more, has been extremely stressful. I've become ill. I have anxiety. And like I said, I'm a low-income senior. I've lived in this unit for 40 plus years. This is my home. And now, you know, I don't have that kind of money to pay that kind of rent, and it's not worth it. The unit is substandard. So I hope that the city, who is supposed to protect tenants, will recognize that what he's trying to do is outrageous and uncalled for. And the units downstairs, which finally were everything is in there is brand new. New walls, new floors, new cupboards, new fixtures, new everything is new. And those have been empty the whole time. So he's losing a lot of money.
And washer dryer.
On those units. And he put the washer and dryer units in the units downstairs, and then took ours out, the one for the building. So we lost that amenity, yeah, like we have so many. So it's just outrageous and uncalled for this kind of increase. And I just thought that West Hollywood protected renters, and so I would hope that they would rule in our favor, and we could come to some kind of reasonable terms. So I guess that's pretty much all I have to say.
All right. If that concludes your statement, then I'm going to ask the commissioners if you have any questions at this time. All right. I've seen none. All right. Thank you. Thank you, Ms. Bolo. So we're gonna ask you to basically stay there, and we'll continue with the next tenant, which is unit number 8. I think that tenant's name is Lorraine Popilarski. Did I correctly pronounce your last name?
Yes, you did. Thank you.
All right.
I did read in the minutes that we could split our time. We can take a few minutes in the beginning, and then we can respond to Taylor Magdal. Is that an option?
That's not an option for tonight's meeting for practical reasons, because we have a large number of people speaking, and it wouldn't be possible to basically do the rebuttal. So that's why I allow everyone to speak 5 minutes and use the full 5-minute segment. All right? So before you begin, please make sure that you state your name and the city of residence, and you may present your position on this case, and make sure that you keep your comments on topic. That's important. You may begin.
Hi, my name is Lorraine Popilarski. I am a tenant at 1021 North Edinburgh. I am in Unit 8. I've been a tenant here for about 10 years. And I don't even understand why we're entertaining this at all, because this is a real estate developer who came in, saw an option to buy this building for cash. He paid 2.5. And the first thing he did was file a legal eviction to try to get me out, since I was the last person to move in with a 2-bedroom. So already it's clear as day that this is a real estate investor who saw an opportunity, didn't understand that there is some rent control, and has been doing nothing but trying to get us out, and trying to use, he's a lawyer, he is an attorney, and he's using these manipulative law loopholes to get rent increases. He has no evidence for base year because he bought the property as is in 2019. How can you even allow someone who buys a property, a real estate investor, to use this loophole? And I know this ROI increase was intended for mom and pop landlords who own buildings for long periods of time. Expenses may, increase over time, and to keep up. And in that respect, it's fair to do, but not for a real estate investor who lives in a $3 million home and enjoys these hearings and putting us through this. And I did submit pictures of what the building looks like, and I hope you had a chance to look at those. He claims he did all these capital improvements, and I submitted pictures of what our laundry room looks like. And I hope you get to see that. He's been cited several times since he's had the property. He's refused to fix things. And again, he's had friends who stay in the unit downstairs because he doesn't care. And it's really pathetic what has been done to us. We've come to this city, we've asked for help, and nobody seems to help us, and we go back and forth with these hearings, which are time-consuming and stressful. And, if you allow this to happen, you are setting a precedent for real estate investors who want to get properties to purchase buildings, come up with all these nonsense evidence. He didn't even have evidence. I asked for evidence. I've asked for actual payments, and allow them to just raise the rent 60% according to this law. And if you allow this to happen, you're going to set a precedent for real estate investors to come in, buy a building, create all these documents of nonsense, and pass this. It's a gross misuse of what you were trying to attend for this. There's no good faith with this landlord. He has just been very manipulative. He's tried to gaslight the tenants, each of us against each other. And I think he enjoys this, to be honest. This is a game for him, to put us through hearings when we just want to be left alone and, you know, just to live our lives in our apartments. And he's had questionable, inconsistent testimony throughout these hearings with this hearing examiner. And I wish you would just look at the evidence, because it should have been thrown out day one. I also, according to your hearing procedures, we had a hearing. He didn't show up. It clearly stated that if somebody doesn't show up, the hearing is binding. And because he forgot it on his calendar, they allowed us to have to go through another hearing and other evidence. I mean, if that doesn't favor the landlord and not protect the tenants, I don't know. I mean, it was just crazy. I guess that's all I have to say. I'm really tired of landlords. It's a clear case of a real estate developer coming in, trying to manipulate this ordinance, which is why you've never seen it before. And if you allow this to happen, it just sets a precedence for real estate investors to come in, buy a building,
That's
claim they're
time.
not making enough,
Thank you.
and, you know, raise rents to whatever they want.
Thank you, Ms. Popolarski, for your statement. Your time is up. Please remain online, and we will move on to the next presenters or testimonies. That would be the tenants from Units 2, 5, and 6 who filed their appeal on September 14th, 2022. And we'll begin with a tenant from Unit 2, Alf Anderson.
They're not present.
They're not present. Okay, so do we have 5 and 6?
Yes, we have Unit 5 in person.
Okay, Seth Gottesdiener, I'm sorry if I mispronounce you, can correct me. Sir, welcome to the meeting. And as I said, you will have 5 minutes to present your case. And please begin with stating your name and the city of residence for the record, and you may begin.
Yes, it's Seth Gottesdiener, and you did a very good job with my name. Los Angeles, right here. And I am in Unit 5. I'll try to keep this pretty succinct, and I just first and foremost want to thank the commission, or the commissioners, for your time. I know this has been a very complex, very nuanced, I mean, for lack of a better word, saga between both the tenants and the landlord. So I just wanted to paint a picture a little bit of the building. When I moved in 2011, which for the record is my base here, the building, as my mother would say, it was the most rundown building on a very nice street. So it was, you know, a little bit decrepit, you know, not really kept up to par with the other surrounding buildings. That being said, a home is what you make of it, and it was, you know, great for me. I had just moved to Los Angeles, and you know, I made it my home. I do want to tell you a little bit about the building since I've lived there. There has been, and Terry touched on this, there has been many things go wrong with it. There has been a sewage leak that was ongoing for a couple years. There has been broken water pipes in my walls that have gone down to Unit 1. My ceiling has caved in, I think, 3 times. There has been mold in the laundry room. The laundry room is now in a state of disrepair. The stairs, both at one point, had holes, and one of them was deemed unsafe by the city. They were forcibly had to repair them and completely redo the back stairs. So that is just a little bit about this building. I don't know its original year of being built, but there has not been, you know, it's not just cosmetic things that need to happen to this building, it's the actual bones. So that being said, a rent increase of this amount does not seem to be deemed warranted based on just what has gone into the building. It would almost require complete renovation. My toilet is broken, the heater doesn't work. Like I've said, there have been a lot of structural issues within the apartment itself. And I do also want to talk just about my rent when I moved in. Although it's great, I will say it was a cheap rent comparatively to my friends in the neighborhood. It wasn't egregious by any means. That was 10 years ago, and Sonia did not raise the rent on us. I also actually want to speak to a little bit. I know there was a remand and there was an attachment. Can I speak on that Taylor had submitted from an anonymous person? It was, I think, sent to you, Miss.
Yeah, was it part of the record? It was, right?
Correspondence
it was
by the
correspondence.
landlord.
Am I able to just speak on that?
Yeah, you may.
I just don't want to go off topic. This letter, this anonymous letter, portrayed Ms. Rebelli as both victimized and also incompetent in her business acumen, which was not the case. I had exactly, one or two interactions with her when we were drawing up a lease, which was just a one-sheet piece of paper. So in that sense, she was not a typical landlord, but there was no negotiating. I didn't try to barter her or tell her that I'd pay her more rent later, or that I was struggling by any means. It was just several, really quick interactions. I agreed on the rent that she said, and that's what it was. Throughout our interactions on the phone, she was of sound mind, sound body, it seemed, and she knew exactly, she was within all of her faculties. So to kind of portray her as this weak, feeble woman, if you met this woman, you would disagree. She had quite a presence and she knew what she was doing. Whether or not she wanted to be a landlord, I can't, testify to that. I don't think that was, what she had wanted to do. So she, was pretty much bequeathed this building from her late husband, and she, in some sense did have pity on the residents just because we had been there so long, so she did not raise the rent, but also attuned to what Terry said, there was no repairs being done to justify rent being increased. I don't have much more to say on that note. I can understand a landlord gradually wanting to increase small amounts. I know, inflation is crazy, yada, yada, everything, but not the amount that he is asking for. Thank you.
Thank you, sir. Commissioners, are any questions? I have a question. You mentioned, well, first let me ask you, when did you move into this unit?
April 2011.
2011. And how much was the rent?
900.
900. Okay. You mentioned a lot of, and I should have asked the other tenants probably, but you mentioned a lot of habitability code violations in your unit. Have you requested the landlord in writing to fix them, to correct them?
The current one or Sonia Rebelli?
The current owner.
The current one? Yes. And for instance, when the ceiling caved in, it was requested and it took a couple weeks to
fix it.
Yeah.
And have you ever called the department or asked for, to inspect the unit? Have you filed a complaint with the department based on the habitability, possible code violations?
I have used the City of West Hollywood website before to request something, but I didn't really hear back, or it didn't really go anywhere.
So regardless of the outcome of this case, and to you and other tenants who have or might have some habitability issues, make sure that you contact the department and request an inspection or whatever the process is to see if there are any code violations. So then the landlord must correct them. All right? Just that's FYI.
Thank you.
Thank you. You may have a seat now.
Okay.
And okay, then that was the tenant from unit number 5, and the last speaker would be the tenant from unit number 6, Andres Santaniello. Is the person?
Hi, good evening.
He's present.
All right. Okay. Yeah, you're online. Yes, sir. Good evening. Please, again, you will have 5 minutes to address the commission, and please make sure that you keep your comments up to topic, and if you go off topic, we may interrupt you. And start with stating your name and the city of residence for the record, sir. And you may begin now.
Hi, my name is Andres Antoniello. I live in unit number 6 at 1021 North Edison Avenue. And I'm going to keep it short. I mean, I agree with with the other tenants. The building, I live here since 2016, probably around 6-7 years. And I mean, I only see that the landlord only, I mean, the previous landlord and Taylor, they only did like maybe some touch up and painting work, but I never see any major repairs in the building. And I have to agree with the tenants. I mean, the laundry right now is a war zone. I mean, there's nothing. There's termites, mold everywhere. My unit is also, I mean, I have been doing repairs by myself because I cannot, like, when I try to contact Taylor, he's never available to send someone to fix, for example, my toilet. I called him 2 weeks ago about a problem I have in my toilet, and he just told me to figure it out, like call someone and fix it, and he will reimburse me. But yeah, I need someone to take care of those problems because I don't have a plumber like in hand right now, like immediately, you know. And that was a problem. Then, and before that, I have an electrical problem, and I have some, I mean, plugs burning out here. And he sent an electrician. He did so bad work here. I'm still having problems. The guy left this wall. I can probably show you right now. He left the wall
No, sir.
open.
That would be something that is out of the record. Yeah.
Sorry. Well, okay. I have my drywall open right now, and I have termites right now in my unit because he couldn't send someone to patch the drywall. So I'm still waiting for that. That was like 3 or 4 months ago. And the toilet, I called him like 2 weeks ago.
Anything specifically about this increase, sir?
And yeah, I think it's not fair, the increase, because of what I'm telling you right now. I mean, the unit is not in good condition. I have many problems in my unit. We don't have the laundry anymore. Yeah, the building had a lot of mold, termites, and it's not. I mean, it's not it's not for anybody to live in this building. It's not safe right now. So that's all I can say, and I agree with all the tenants.
All right. That concludes your comment at this time, sir?
Yes.
Okay. Thank you. Also, please remain online. We'll continue our meeting now. And we just want to ask if the commissioners have any questions. All right. Same thing, sir. If you have any habitability, code issues, housing issues, please contact the department and follow their lead on those issues, all right? Because we can't really address these issues tonight. So with that, we had all the tenants who wish to speak tonight, and now we're gonna allow the landlord or their representative to present their story, their statement. Is the owner, the landlord, online? Ms. Secretary.
Yes.
Yeah. All right. Sir, oh yeah. Can you hear us? You need to unmute yourself.
Taylor, can you hear us?
I can hear you perfectly, Commissioners.
Okay, all right, sounds good. All right, sir, now you have 5 minutes to address the commission. And again, please begin by stating your name and the city of residence for the record. Yeah, and please make sure that your statements will be on topic and don't go off topic or that you will may be interrupted. You may begin now, sir. Thank you.
Thank you, Chair. My name is Taylor Megdal. I am the owner. I am, in fact, an attorney as well, as one of the tenants pointed out. I am a resident of Los Angeles, and this is one of 2 apartment buildings that I own. So to say that I'm some huge developer and investor is a mischaracterization. I did buy this building 2 years ago, and unfortunately, I didn't do the requisite due diligence on the amount of money each of the tenants was paying, and that is on me, and I take ownership of that. It was purchased at a court auction, so some of the due diligence was spotty, but apparently there was the actual rent roll on the file room, which I did not see. When I purchased it, I noted that there were 4 specific residents that, you know, were young folks who I am not used to seeing, you know, benefiting from these crazy cheap rents. And I made some introductions to the previous seller who had passed away and her relatives. And the information that I gleaned, which yielded actually that anonymous testimony that was sent both to me and to the commissioner and Eric Fountain specifically, was testifying to the fact that Units 1 and Terry's unit, which is Unit 7, are fair, I would say, and I think rent control mandated, you know, policy-wise rental units. They've been there for 30 or 40 years. Terry, I think, has even been there for 40 years, and I think Unit A has been there for about that time. And they made rental agreements that were consistent for when they started their occupancy. Now, they're also really inexpensive because ownership hasn't raised them once in 40 years, but at least they were executed at a market rate. The other 4 units, which unfortunately are also leading to Unit 1 and Terry's unit number 7 being, you know, unfortunately in this mess, they were consummated with an elderly lady who was 70 years or older. All 4 of those leases were at over half or more at the time of actual consummation of lease, over half off market rent. And there is statutes that your Attorney General will probably be able to apprise you of, but it doesn't matter the intention of the parties, actually. It doesn't matter that the tenants who signed those leases, you know, thought that's what they were trying to achieve, a good rent, or they thought she was being generous. If you consummate a lease with an elderly over 70 years old and it is on its face completely unfair, it's effectively, in the eyes of the law, fraud. And we'll have another hearing, I think, about that topic. And that's not to judge these residents. And I don't begrudge them for trying to get a great deal on a rental unit. But I used West Hollywood's public data on the average unit in their class of units. And at the time they rented it, these were young kids at the time, dealing with a lady who was 70 years older, and it was half off rent. And then for the next 20 or 30 years that they've lived there, they haven't had one increase. This is exactly why the statutes are on the books, for exactly this scenario. Because now I'm stepping into the shoes of her, and these were fraudulently induced leases. Period. And I take particular note, and actually I strongly disagree with, I feel like, the staff report, which is insinuating in some way that if you can't provide the 1983 data, you can't then at all consider the expense side of the equation, which, if that's the case, then the statute is basically null and void, because there won't be more than 2 owners probably in your entire city that have owned the building for 50 years and can produce every electric bill, every gas bill, every trash receipt from 1983. Even the people who probably have owned it for the last 50 years haven't kept the files from 50 years ago. So if you're going to use a threshold that would in some way imply that in order for this statute to apply, you have to have actual bills from 1983 and checks, then, you know, effectively, you basically are neutering the entire statute. And, you know, I think probably a court, not a commission, should take a look at that policy. And as far
Thank
as...
you, that's time.
Your time is up, sir.
Yeah, I mean, but just really quickly also, as far as substantial evidence, I provided 500 pages.
Okay.
And when you guys handed the hearing to the hearing officer
Thank you,
a
sir.
second time, I provided a property manager's assessment and estimate.
All right. Thank you,
I've
sir.
actually tried.
Thank you, sir. Commissioners, are there any questions for the landlord? Commissioner Maggio, please.
Sir, have you addressed any of these issues that were presented to you, the mold, the laundry room? I'm curious to know why you have 2 empty units and plumbing. And also, I want to make this personal comment that because someone's 70 years old, they can't make a logical and reasonable decision. That sounds like an ageist. So I'd like you to explain that as well.
Chair, if I can real quick, I think questions relating to the habitability of the units and claims of disrepair aren't relevant to the appeal, but as to the open units, that was part of the hearing.
All right, could you explain then the open units?
I agree with you, Ms. Natalie Zeus. Thank you.
Yeah, and Commissioner Maggio, I'm not trying to insinuate that anybody over 70 can't make a good business decision. My dad's over 70, and my uncle's also over 70 and very equipped. I'm just telling you what the law says for the benefit of being a lawyer, that if you are over 70 years of age and you enter into a contract and the terms of the contract are patently unfair, i.e. 50% of market rent, it's deemed to be fraud. It's elder abuse. It's just as good as fraud. So I'm just talking to you about a legal position, and in no way am I trying to insinuate that every 70-year-old can't make a good business decision.
No,
but,
but you have made it, you have emphasized it over and over again. So
yeah, it sounded like that, sir. But Commissioner, if he responded, so I'd like to.
I'm satisfied with the answers. Thank you.
What about the 2 open units?
He didn't answer the 2
Sir,
open
would you like to open about the question regarding the 2?
Rented the 2 units that are already repaired.
Regarding habitability and repairs for the 2 open units?
Okay, yeah, I'm happy to explain that, Commissioner Maggio, and I addressed it last commission, which was 8 months ago, and I also addressed it in 2 hearings to the hearing officer. Those units were leased at the beginning of the COVID, and both tenants are not living there, not paying rent, but I don't have the legal right to evict them. So it's the answer remains the same.
Okay.
But again, as for purposes of the hearing officer's analysis, my submitted appeal and my analysis.
Sir, you answered the question, so that this is additional information, so that's fine. You answered the question. I appreciate it. Thank you. I have another question. Okay, Commissioner Kirpis, you, and then I will ask my question.
Yeah, I have a question. I think this is what you were going to say, Mr. Magdal, but can you explain to us those 2 units, isn't it true that you calculated those 2 units as if receiving the rent, although you haven't been, you calculated as receiving the rent in your application so as not to harm the other tenants? Okay, I just want to make that clear for the...
I acted as if we were receiving every dime of the rent for both those units at the contract rental rate, and I annualized that over 12 months, and that was phantom money because we never actually collected that.
Thank you.
And I just,
all right, Mr. McDowell, I have a question for you. You mentioned this is your second building. The other one is also in City of West Hollywood. It may not be relevant, but the reason why I'm asking is, were you aware of the rent stabilization ordinance, and that the property where you were purchasing was under rent control?
Yes, Commissioner, absolutely was. I was aware that it was in rent control, and the other properties in Santa Monica that has equally, I would say strict rent control ordinance.
So
But I also was aware that an owner is allowed to raise the rent to get a fair and just return.
Okay.
And
So
I'm not getting a fair and just return with people paying rent from 40
right.
years
So
ago.
you answered the question. So you were aware that the building is under rent control, this particular building. Is that correct?
I was.
Okay.
I was.
And were you aware of specifically of these units' rents when before or right after? Where did you become aware of that?
Yeah. Commissioner, I should have been aware of them. I wasn't.
Okay.
They were, the tenant's testimony that they were available to me on a Dropbox is correct. I did not see them. It was a court ordered by the city of West Hollywood because they effectively took the property back from the old owner. So when you say she was a competent businesswoman, she was so competent that she signed 4 leases at half the rent of when, and then she doesn't raise them for 20 years, and then has the city impose
Yeah, but I don't want to talk about it. So I wanted to know if you were aware of the rents, but that's beyond what I asked.
I was aware of it.
Thank you. Thank you, sir.
I was not aware of the specific rent, but it should have been available to me. I should have seen it.
Got it. Thank you. Appreciate that. Sir, please remain online, and the commissioners, they don't have any questions. So at this time, I will close the oral argument portion of the hearing, and then, appeal, and then I will ask the commissioners if you have any questions. You can ask staff, legal counsel or the manager.
At a certain point, could we have a 2-minute recess before we dive into questions and discussion?
Commissioners, would you like to take the 3 minutes? Will be fine? Okay, we'll take 3 minutes recess, and we'll back at, what's the time? It's 8:15 now. We'll be back 8:20.
is Seth. Oh, Unit 5, okay.
I still didn't see the.
All right, everyone, it's 8:20, and I'll call this meeting back to order. Okay. Well, this is the time for the commissioners to ask any questions if we have to our legal counsel. Commissioner Kerpis.
So I think I have a question. I'm not sure if it's a question or a statement, but I'll make it as a question for legal counsel. So I listened to the testimony tonight. I'm mostly focused on the tenant's testimony, and I would say maybe one tenant slightly hit on the issues that are in front of us tonight. Most of them did not, and I don't blame them for that. How would they have known? I feel like the issue that we're going to be talking about tonight is whether we're going to switch from one formula to another formula and do this 60%, or do this, just look at the CPI over time, which makes all of their comments completely irrelevant. And I don't feel like that they had enough notice, or any notice at all, that would be the discussion tonight. So how does this become a fair appeal hearing for them? It's like we changed the rules at the appeal of their own appeal. I mean, they appealed it based upon the rules that we were playing under, and now we're coming up with potentially a new formula to go off of, which erases all of their testimony on habitability and the conditions and everything. We're only looking at CPI now tonight if we follow this proposal. Kind of want to get your thoughts on that.
A continuance?
I'm just wondering.
Let's see what the legal counsel is going to respond.
So my response to that is, well, one, I don't think that we're not using a different formula. The formula for fair NOI is the formula that's in the code, and that savings clause that was referenced doesn't allow the commission to deviate from the formula. It allows it to modify it, but the commission isn't, for example, using a completely different formula that wasn't in the code. The RSO allows the commission to modify it. I don't know if the issues of habitability and their concerns relating the overall quality of the building really factors in to the equation, even if the formula wasn't modified, because the formula isn't looking at the quality of the building. It's essentially a mathematical formula to determine whether or not a landlord's getting a fair return on its investment. So I don't, if maybe some of the tenants were bringing up specific issues about the formula, maybe, but I don't know if just general habitability arguments affects the formula either way.
Well, I think the tenants are trying to use habitability discussion because it has to do with, it would be relevant if we were considering whether he actually paid $300,000 for capital improvements or he paid $100,000 for capital improvements. I mean, the tenants are talking about issues that that would put a value to that amount. Well, we're now saying it doesn't matter what he paid for capital improvements because we're not even looking at that. And that is, I feel, a significant change from the game that they were playing in the last couple of hearings.
No, and I understand that, and I think just my response to that would be the landlord, for his claimed current expenses, submitted invoices. And so I think then that would just be a weighing of evidence of, do you trust this invoice from some contractor doing work, or tenant saying, we saw that he submitted that invoice, we don't believe it because we've never seen anybody do work on the property. That's a weighing of evidence issue. So again, I don't know if it's, for lack of a better term, switching the game. And I also think that, the staff report was provided to all the parties 10 business days, right, in advance. And so everyone was well aware of what staff's recommendation was, and everyone was free to comment on that as well. So, I mean, it's not noticed in the sense of discussed at the hearing, but they're not hearing about it for the first time tonight.
So would it have been, would tenants have been allowed this evening to spend 5 minutes each on the pros and cons of whether the city considered eliminating the annual, or the cost of, what am I thinking of? The operating expenses. So would that be relevant evidence or relevant statements tonight by the witnesses if they were to spend their 5 minutes just solely speaking about that issue?
Yes.
Even though it wasn't discussed in in any hearing prior to this? I mean, it was only submitted through the staff report, which...
I think because the staff report addresses it, it would be sufficient.
Okay, thank you. Vice Chair?
Am I correct in assuming that the two pieces of correspondence, one from the landlord and then the other from a tenant, we are not to consider that in our deliberation because they were not part of the hearing?
If they were just written statements, that's fine for you to consider. If there was evidence attached to it and it wasn't evidence that's also included in this packet, then that would be new evidence.
Okay, thank you. And my other clarifying question is, per the city's RSO and other ordinances, if a tenant enters into a lease well below and negotiates a rent rate of well below market rate with a landlord who is upwards of 70 years old, would that constitute fraud?
Okay, so there's nothing in the RSO that addresses contracting with anyone that's elderly, and there's, to my knowledge, I'm not aware of what this, I wasn't clear if it was a law or an attorney general's opinion or a statute. I'm not sure what the land was referencing about whether or not anyone over a certain age is unable to contract or to contract for purposes of a lease. I'm just off the top of my head, I'm not aware of a law that says that.
Thank you.
Thank you. Other commissioners have no more questions? All right, so then we shall begin our deliberation. Who would like to start? Commissioner Martz, please.
All right. I'll try to be as brief as possible. We went through a lot of this in the original, so I don't think we need to go over everything again. the landlord failed to follow our instructions, and then the hearing examiner also failed to follow our resolution and instructions. So that's where we find ourselves today. Just kind of going through some of the comments, I don't give any weight to the anonymous letter. I don't think it is relevant to what we're discussing tonight. And then, especially when we have a complex case like this, we always have to go back to the building blocks, the starting place. It's our municipal code, or RSO. And it does say the landlord is entitled to a fair and just return. We gave the landlord a chance to prove that, he was going for way more. Didn't happen at the original hearing, didn't happen at the remand hearing, so here we are today. But the RSO still requires that we provide a fair and just return. So we're forced to find the most appropriate resolution based on the RSO rules and constitutional requirements. A lot of times, myself, this commission, and just in life, we want that black and white answer. It doesn't always exist. I think this is a perfect example of that we have to find the best resolution available to us that's based on the RSO and our constitutional requirements. And that's where this savings clause comes in. And I think when the drafters, back whenever this law was written, were putting this together, they foresaw that sometimes we would run into a situation where someone buys a building and they aren't able to prove it. But there still has to be a way for the fair and just number to come from. And if we don't have the evidence that we need, we turn to this savings clause that allows us to craft a different resolution while still following all of the requirements of the RSO. And that's where the staff's recommendation comes in, which I agree with the staff's recommendation, which is to provide a just return, but doesn't go above what the landlord is owed in this situation. And I fully take Commissioner Kirby's concerns to heart, and I fully hear where you're coming from. But we're confined by what the RSO requires us to do, and I think staff is correct here. I would also say I'm extremely troubled by the numerous reports of the maintenance issues that go on at this property, and as my fellow commissioners have said, we urge the residents to contact the city, even on a daily basis, to resolve this, because this is not the kind of landlord's actions that I want to see in our city if these things are true. And one landlord or one tenant saying something may be dishonest, but when you have 5 or 6 saying the same thing, it concerns me greatly. I also find the landlord just not to be credible. And the attacks that the leases were fraudulent, I find that to be improper and based on a very flawed legal analysis. A cheap lease doesn't mean that this person was old and stupid and doesn't know how to enter into a lease. I have a former law partner that's 84, and he's probably smarter than all of us in this room combined. I also know people who are my age, pushing 40, who are some of the dumber lawyers. So age is not, the thing here. And I don't know this lady that entered into these contracts for anything, but there are other reasons besides just the market why we pick a certain number. If the market says it's 1,000 and they're giving 500, maybe they like you, maybe their kids are dating you, maybe she realized her property was not in great condition and is saying, I think I should probably not charge you market rate because the lady next door keeps her place up and I just don't want to do that. So you can move in here, it's going to be $500. There are many reasons beyond fraud and taking advantage of an old person. And to just blatantly say that these are fraud, no, that's garbage to me. So for those reasons, I think the staff's recommendation is correct.
Thank you, Commissioner Martz. Commissioner Corpus?
Thank you. So I want to start out just by saying a couple comments in general about some of the things that we heard tonight. I want to explain that, so no matter what happens tonight, even in the worst case scenario for the tenants, best case scenario for the landlord, that this increase were to go into place, even if we were going under the old, the previous, from the last hearing, no one is being brought up to market rate. You will all remain under market rate rents, even with these increases. Not to say these increases are not going to hurt, they will, but I just wanted to clarify that. You're not being brought up to market rate. You will potentially see an increase. There are certain things that the landlord is required to do, which are building code issues and heating issues, plumbing issues, and then there are services that are offered. There are the laundry room. There are issues like that are services that are then taken away. You all have the right, and I said this at the last hearing, and I hope that you did, and I'm disappointed if you didn't, but I specifically gave instructions that you should go to the city and ask for a rent reduction hearing. For any of those issues that the landlord, you've given 30 days to fix or to return the service and they haven't, then you go to the city and you ask for a rent reduction hearing, and you can get your rent reduced if those services have gone away, or and then there's some code violations, which are those building requirements that the city will then take it upon themselves to enforce that they fix. So please do that. Follow those instructions. We gave you that information last time, and I hope you will listen to us and do that, regardless of how this turns out. I agree that we have a duty at the end of the day to make sure that that the landlord has a reasonable return on his investment. That is the law, and that's, I think I said it in the last hearing, that is the only thing that allows rent control and rent stabilization to exist, is because we give that, the courts have required us to give it, we give that out for the landlords to be able to get a reasonable rate of return. I am not certain that that's what we're doing here tonight based upon the recommendation. I do believe something that these rents are too low for a reasonable rate of return. I mentioned that in the last hearing, and I suggested that the tenants prepare for an increase. I expected that the landlord would listen to the commission and go back and provide evidence of whatever year he could, but it doesn't sound like he even attempted to do that. It sounds like the hearing examiner tried to use what was available to them to come to a conclusion, so we wouldn't be in this situation again. But he or she failed at that, didn't follow our instructions either, and so it's back at us. And I feel that we are a combination of us being asked to solve this problem for the landlord, while also knowing in the back of our minds that we do have a duty to make sure the landlord has a reasonable rate of return. This proposal tonight, suggesting that we only look at the base year CPI and the current year CPI and take 60% of that, the difference, and just automatically associate that new dollar amount to the landlord, I don't think is, I think it's better than what the landlord has provided, because at least there's some basis for it. But it's like saying, I mean, there's a reason why we don't allow landlords to take CPI, or don't allow them to bank the adjusted annual increases. They need to take it when they have the opportunity, or they lose it. Mm-hmm. I know this landlord was not there over the years, so it's not that this person, he decided not to take the adjustment increase each year, and now is coming back to us and saying, oh no, I want it now, I'm gonna ask for this. But I think it does set us up for a lot of the smaller landlords who have less turnover in their buildings. Opens this up to a new precedent that they will simply sit at home tonight and they're going to get out their calculator and they're going to figure out how much their rent was in 1983, and they're going to figure out what their rent is today to see if the calculation using this 60% CPI increase, whether it benefits them or not. And we're going to, in the cases that it does, we're going to see applications tomorrow. That's my concern about following this. I don't think that this is, although it sounds like we are equitably applying this across the board, I don't think that the gentleman, let's say, who testified this evening, who moved in 2011, paid $900 in rent. First of all, that is not below market. I moved in 2011 into a one-bedroom apartment that doesn't have any problems that, that this building has, and I paid $12.99. This building sounds like he moved into kind of a dump, and that's not my building. It's only a $300 difference. So it wasn't way below market when this gentleman moved in. But in 2011, he moved in, so he's going to see an increase of the CPI from 1983 to 2022, and that's going to be and the difference that's going to be applied to his rent, even though he should only be looking at it. If we're just going to take a formula that we're using here tonight, he should start in 2011. And what's the CPI increase from then? Because that was market in 2011, or pretty close to it. Those are my concerns about tonight. I do think at the end of the night we have to come up with, we have to make sure that the landlord has a reasonable rate of return. But I'm also conflicted by the fact that the landlord doesn't seem to be doing his part in this. We saw his tone change completely from the last, and the reason I noticed is because I watched the last hearing, the April 14th hearing again today, so that I would have it refreshed in my memory, all the issues that we had talked about. And his tone then was completely different than tonight. There were no allegations of fraud back then. This is all new tonight. So I'm a little surprised by the change in tone, change in strategy, when we set out the roadmap and there was no attempt to follow it. So I don't know how the courts would look at it. I mean, if I were a judge, I would think, oh, well, the commission gave him an opportunity to prove it. He didn't. So even though he's not getting the reasonable rate of return or investment return, he can come back at a later date to present his case again. There's nothing that stops him from doing that again. So I'm kind of in between that spot where either we just deny this completely and give him nothing and let him start all over, or we come up with some sort of reasonable rate.
Thank you. Commissioner Maggio?
I need another few minutes.
Okay.
Go to the Vice Chair.
Vice Chair.
Well, I want to thank Commissioner Martz for his comments because it laid out my thoughts exactly, and so I don't need to repeat them or try to even match them. And in a case like this, I'm like tempted to want to remand it again, but already the landlord has been given the opportunity to bring forth adequate documentation to support, a 1983 base rate, and he did not do that when given 2 opportunities. I don't think he would do it if he was given a 3rd opportunity. So I am inclined to go with staff recommendation on this.
Commissioner Maggio, thank you.
Unfortunately, I have to agree with the staff recommendation, although I do agree that the landlord is definitely not doing his part. I was particularly bothered, although I don't think it really will affect the case, but I feel his comments about a 70-year-old really represents a person who might be an ageist, and that bothers me. In regard to the problems that do exist in this building, and this is for the tenants, there's no reason for you to have mold without that being taken care of. There's no reason for you not to have a functioning laundry room without that being taken care of. There's no reason not to have your plumbing in order. Not to mention you are allowed to have your apartment painted every 4 years and your carpet changed every 7 years. I would recommend and suggest that you pursue that, because they all equate a rent reduction if certainly these issues are not rectified. Unfortunately, I will have to agree with, as I said before, the staff's recommendation. That's all I have.
Thank you, Commissioner. So I'll be brief because I'm in agreement with most of the statements made by the fellow commissioners. I just want to mention that for people who are watching us tonight and for the parties that I'm sure you're probably aware that the Rent Stabilization Ordinance is the very first law that was adopted by the City Council when West Hollywood was incorporated in 1984, and that basically that demonstrates how important the rent stabilization and housing rules and policies are, play what an important role they play in our city. And we as a commission, of course, we have a duty to uphold the RSO. And the purpose of that rent stabilization ordinance was to protect, and is to protect, the rights of the tenants from unjust evictions and unjust rent increases. But at the same time, the same ordinance provides that fundamental right to the landlords, property owners for a just and reasonable rent increase, rent return. And that's what the landlord is exercising under, in this case, he's exercising his rights under this law. And that's what we are looking into. Well, it is clear to me that the hearing examiner erred by not complying with the remand instructions that were provided by this commission. And the examiner deviated from the RSO, from what the RSO says. And all that was clearly explained in the staff report, that also the tenants and the landlord obviously had a copy of. Well, now that I believe that the tenants and the landlord, both parties had that opportunity to address the commission, to address those issues during the remand hearing and to address these issues tonight before us at this appeal. But as Commissioner Kerpis correctly noted, that all the testimonies, unfortunately, were about habitability. About we understand the importance of that, the repairs and all that stuff, but we didn't really hear from the tenants any specific statement or a position on the formula or the model used for the increase that is suggested here in the staff report. And I agree also with staff that the commission has the authority to determine the fair net operating income, NOI, particularly because the parties have submitted the best evidence that could be used. And since the examiner erred in the remand hearing, and the parties did not submit any additional information, so I think we all agree that this should be resolved. And I think the resolution I see tonight by affirming what staff recommends. I'm in agreement with the formula used in the recommendation, but I also wanted to maybe understand a little bit more, Mr. Natalizio, what Commissioner Kerpis said regarding, for example, that unit number 5, who is not, well, he's a long-term tenant, obviously, he's been living there for more than 10 years, but he didn't move in 40 years ago. His rent was like $300 or something. And I agree that $900 at that time was probably close to the market rate. So I wanted to know why the same formula applied to that tenant and maybe the other tenant, but we didn't look into or maybe staff did, look into the specifics when and who moved into the unit and how much they paid. I mean, we know how much they paid, but can you answer that question? Can you explain why we applied the same rule to those tenants or the tenant?
Sure, Chair. I think the summary and the complete answer is just that's what the RSO says. The RSO doesn't say that each unit has its own individual base year in comparison to the current year of the application. The RSO looks at one base year and compares that NOI to the NOI of the current application year, and then follows the formula resulting in the fair NOI. And the purpose of this is essentially to determine if at the time of the base year, when you're looking at the NOI, what was that, and is the landlord in current day making less than what the landlord should be making? And that's the fundamental basics of what the formula is whether or not the landlord today is making less than the base year, along with the 60% the CPI applied. And if today they are not, then their landlord is not getting the fair NOI. And so the formula just requires looking at one base year.
Which is 1983.
So the code presumes 1983 as the base year, but the landlord is free to establish a different base year.
Which the landlord had the opportunity and didn't provide the necessary documents or evidence to establish a different day.
In this case, the landlord wanted 1983 and did not suggest a different year.
Correct. Okay. So thank you for confirmation of that. And I also agree with what Commissioner Kerpis mentioned, whether it's relevant or not, but this is a rent increase above 3%. We know that, or whatever the percentage is. I wouldn't use 3%, or whatever the percentage is under the annual general adjustment, which we didn't have for a few years now. But even with these increases, the rents are below market rate, and we all know what the market rate rents are, at least the average rent in West Hollywood. So in a sense, I understand this is the increase, that nobody wanted to have that increase, but that's the fundamental right of the landlord to exercise that increase. And that right is given by the RSO. At the same time, the RSO protects the right of the tenant from any unjust rent increase, because probably the landlord, if there wouldn't be for the RSO, for the rent control or the rent stabilization ordinance, the increase would have been probably much higher than the tenant's gonna get. So with that said, I don't want to go into any more discussion about the habitability and stuff, but I would say that I'm in agreement with staff's recommendation, and I want to thank the staff and the legal counsel for this very detailed and very comprehensive and easy to read and understand report in this case. And I know you want to say something.
No, thanks, Chair. No, and I did just want to address Commissioner Kerpes. Comments. He makes a legitimate point about not wanting to create a situation where landlords are just going to do math, and submit these applications. And I think there's a couple of things to address that. One is that this is a very unique case. I don't know if, maybe there could be, but a situation like this where rents are, in some cases, unchanged for decades or a decade plus, that's, I think, very unique. And I think that in this situation, the reason why staff was looking at this savings clause in determining that just looking at the rents alone, there wasn't a just and reasonable return. That might not be the case in every NOI case that comes before the hearing examiner and ultimately the commission. And so I think this is a very fact-dependent analysis that we're doing right now. And I think, as Commissioner Martz said, is that this savings clause is really giving the commission the flexibility for when you have these very unique situations to be able to address a just and reasonable return. But this also doesn't mean, and I think this is what Commissioner Kerpes was talking about, it doesn't mean that there could be a scenario where a landlord comes in and says, oh, I don't know what the base year is, and then just do this quick math for me. The commission could find that if a landlord is not complying with the obligations of meeting both the income and the operating expenses and the NOI to deny that application. So I don't want there to be a misconception that now this is going to be the case every time, and the code still requires to be followed, and that this saving clause is really only to be enacted in a very unique situation like here, and otherwise every landlord should be expected to submit both income and operating expenses for a base year and its current year.
And thank you for that comment, because that's very important. And Commissioner Maggio has been the longest serving commissioner. I'm not sure he remembers any other case like this. And I've been on this commission since 2004, and I can't really recall any other case, maybe one. But I appreciate that clarification, the comment from the legal counsel. And I also want to, the last thing I want to mention is that the commission cannot come up with a alternative formula or module to allow this NOI rent increase. So we have to use what the law provides, and the savings clause permits the commission in this case to ensure that the just and reasonable return is properly exercised and established. So with that said, I'm in favor of the recommendation, and I'm going to support the staff's recommendation. Okay, so let's do the final two questions from the Commissioner.
Two questions. Excuse me. One is, although it doesn't appear that this is going to happen, but what would happen if the commission felt that the landlord did not meet his evidentiary requirement and we just denied this completely? What would then happen?
It's like a hypothetical question.
Yeah. Well, I mean
that
is completely within the commission's power. If the commission found that the landlord was provided all the opportunities and found that the landlord failed to meet the requirements of the code, the commission is well within its power to just deny the application.
And do you see any, I know this would just be speculation, but like in your legal opinion, do you fear a decision like that would have a implication on other cases or rent control in general, or?
I don't know if I have a necessary legal fear. Again, this is all within the commission's discretion. I can only just provide legal advice, and if a decision like that was ever challenged, we would defend it. So I think this was really just staff's attempt to utilize that savings clause and prevent an argument by the landlord, that this wasn't being met. Okay.
And my second question is about the savings clause. So staff used the savings clause to come up with this formula tonight. Would it be outside of the realm of possibility that that staff were to use use the savings clause to the same formula that you're talking about, but look at the most recent tenant and start from that year forward?
So you're saying well, just to be clear, so the staff's not using a different formula. It's using the same formula that's in the code. It's just recommending that the commission modify a provision of that formula. And so is your question, could the commission modify the formula to change the base year?
Yeah, I mean, I know that the landlord chose 1983 as the base year, but failed to provide the evidence for that. So then staff utilized 1983 based upon just a presumption that that's what the code is, right?
So staff utilized 1983 because the evidence in the record showed, again, reliably what the rents were in 1983, and we have that because of the registration forms. So for example, if the commission were to choose 2011, just as an example, there's nothing in the record that shows what the rents were in 2011. So that's why staff utilized 1983 as the base year, because there's at least
Doesn't the evidence indicate that no one has increased their rents over the years? I mean, doesn't the evidence show that the rental unit that started in number 5 was $900? I mean, the evidence is all there. We just haven't.
I don't know off the top of my head if the rates changed at all from when tenants first moved into whatever other year to present. I don't know off the top of my head. If the commission found that the record does show that the rates did not change, for example, from 2011 to present, I mean, presumably then, yeah, the commission could utilize that different year. They would just have to say on the record why they're using that year.
I mean, I just think that's a much more fair. If we're going to be altering, I think we're changing the formula. But if we're going to be changing it in any way, I mean, I think that's a much more fair way of doing it, and it still allows, again, no matter what we decide tonight, the landlord can still tomorrow file this again for a new. There's no limit on annual or the rate of return, the NOI. Can't even remember what it stands for. So I would just suggest that we do something like that doesn't make it, and it also makes it very specific to this case. It doesn't make it a blanket rule for 1983 for all other cases. Because I do know of, I haven't heard him in a council meeting recently, but there's a gentleman that is a duplex, and it's like $238 a month or something like that. He used to come to every single city council meeting and talk about rent control. He supports it, but he was being hurt by it because he was only being able to charge $298 or whatever it was. And I know that if he does the math on this equation, he could come and increase it.
Where can we find the rates for the increases?
I mean, they would, again, whatever was submitted in this case is in the appeal packet. I haven't looked at them for the specific questions being asked, so I mean, I would have to look through the record to see if what's being suggested exists, and I think we'd also have to know what the year is that the commission would even be looking at to determine if that year's in the record.
Yeah, for that year.
Yeah, I mean, I think we'd have to look it up, but I think what he's asking is what would the CPI be in 2011 for that same calculation?
Well, I mean, I think if the commission was going to go with a different base year, the instruction from the commission we'd have to come back with an updated resolution, because the staff would then have to go and do all of the calculations. We'd have to redo the formula, and then we would also have to redo the calculations for the maximum allowable rent and change the resolution and do all that. So I don't know if we could do that tonight.
Yeah, we can't do the calculations clearly tonight for that. So now, we
remand it until that information is really brought to us.
we're probably not going to remand, Commissioner, but what we can do is, why don't we, okay, so let's first see, since the commissioners, you know, it seems like the majority of the commissioners are kind of supported the staff's recommendation. So why don't we just make a motion and go based on that and see if there will be an alternate motion on that, right? So, and see which one will pass. Is that how we can do?
Sure. I mean, if someone who wants to make a motion and it gets a second, that can be voted on. If there's a substitute motion and that gets a second, that can be voted on, or, you know, commission can continue deliberating. So this.
So the first motion would be the substitute motion, or the first motion would be what is recommended?
It depends on who makes the motion. So.
Okay. So let's see who's going to make a motion.
So to start it, and since mine's the odd one, I'll make a motion that we, basically the idea would be to take the staff recommendation and approve the staff recommendation, but instead of using 1983 as the base year, use 2011. That would be my motion.
So just changing the year, but keeping the motion, or rather keeping the staff report as suggested.
Yeah, we're using the same formula that the staff is suggesting. We're just, instead of 1983, we're using 2011 in the calculation.
Are you going to make that motion?
He already made the motion.
I
He already
moved
made the
that.
motion. So I was just thinking.
All right, and because I wanted to second the motion.
Oh, yeah. So you want to second that motion? Yes. All right. So we have a motion made by Commissioner Kerpis and Commissioner Maggio seconded that motion. So let's start the roll call vote, please, Ms. Secretary.
Commissioner Kerpes?
Aye.
Commissioner Maggio?
Aye.
Commissioner Martz?
No.
Vice Chair Ayers?
No.
Chair Topshin?
No. So the motion didn't pass.
I will
The
make
motion.
a motion to adopt resolution RSC number 22-620, a resolution of the Rent Stabilization Commission of the City of West Hollywood reversing and modifying the hearing examiner's decision as to application number I-152R.
I'll second.
Okay, we have a motion, we have a second. Ms. Secretary, may we have a roll call vote?
Commissioner Kerpes?
No.
Commissioner Maggio?
No.
Commissioner Martz?
Yes.
Vice Chair Ayers?
Yes.
Chair Topshin?
Aye. Motion passes. Thank you. Now, well, for the parties who are still online and watching or listening us, if you have any questions about what you heard tonight, and if you have any questions about the final outcome of this appeal, please contact our staff. And the phone number is, which I always forget, and the number, let me give you remind the number. It's 323-848-6450. That's the direct number to the Rent Stabilization Division of the City of West Hollywood. So that concludes our appeals we have for tonight, and moving on to the next item, which is new business. We have nothing scheduled under that item. Anything from staff at this time?
Nothing further from staff.
Okay. Next is public comment. Ms. Secretary, anything at this time?
No public comments at this time.
All right. We don't have any speakers. And I'm moving on to the commissioners' comments. Commissioner Maggio, please.
I'd like to start first by thanking our secretary for our holiday gifts.
Oh, yes, thank
That's
you.
very thoughtful, and I want to tell you how much I like you and how valuable you are to this commission, and thank you. I also want to wish the public a happy holiday. I celebrate Christmas in particular, and those who celebrate Christmas, Merry Christmas. And I believe Hanukkah's in there. And that we are looking forward to seeing you at the beginning of the year. Please stay tuned. Thank you.
Thank you, Commissioner. Commissioner Vice Chair.
Sure. Just want to wish everyone a happy holidays. Thank you.
Commissioner Martz, nothing. Commissioner Kerpis, nothing at this time. First, I want to ask, going back to, I hate to do this, but Mr. Manager, how can we ensure that, let's say the tenants are not going to file complaints for whatever reason, regarding the habitability or any reduction of housing services? Is there a mechanism that we can use so that the building can be inspected without the tenants formally filing a complaint? Because it seems like all these tenants are complaining about the conditions in the units in the building. I don't think it's fair to them.
Well, they can obviously file for a decreased case, and I do believe that your next appeal, you'll be seeing all of these folks again.
Okay.
My comments back about
So
chastising them for
it's
not doing this.
apparently being utilized. But that said, for some of the issues that were mentioned tonight, the appropriate course in addition to possibly filing for a rent decrease would be to contact the I hope I get this right because they changed their name, and it's late. I want code compliance. They used to be called code compliance.
It's no
Danny
longer.
Rivas is going to be really mad at me. But if they contact our division, we will refer them to code compliance. And also some of the issues that were mentioned actually might not necessarily be handled by code compliance specifically, but rather by the health department. And we can provide all that information about how to get in touch with our code department or get in touch with the health department for the county. And if a citation is warranted, then a citation will be issued. And that's how they can try to resolve these issues.
Thank you, Mr. Manager.
Based on what we've heard tonight, is that, are you comfortable with having maybe a staff member call at least the tenants who spoke tonight to say, I don't know if we can offer a code enforcement officer to go out and look or what, but to walk them through these issues to make sure that they are taking the steps necessary. I know we can't do it for them, but we've heard enough tonight to me to think that it warrants at least a look by the city to see if the building's still structurally sound.
Well, they do need to reach out to code themselves. But I can have staff follow up with the tenants that complained about issues that might be code related, and just to give them the code compliance division's information if they don't have it already.
Yeah. So in other words, it has to be initiated by the tenants, and this is when I remember that we had this discussion, and the commission really supported the idea of having a proactive code enforcement inspections, skip-like inspections. Unfortunately, they didn't happen in our city, but hopefully we can maybe contact the council members and see if they can look into that differently, since a lot of things changed and the council changed. So, but that's another discussion. Thank you, Mr. Manager, and I also want to say happy holidays to everyone, since this is our last meeting in December in this year, and we're going to meet in January of 2023. Time flies. It's just crazy. And I want to wish everyone Merry Christmas, Happy Hanukkah, Happy Kwanzaa, whoever celebrates whatever. So this is a wonderful time, wonderful season to celebrate holidays, and I wish you wonderful and also prosperous New Year 2023. So with that said, I will adjourn this meeting until the next regular meeting of the Rent Stabilization Commission to be held on January 12th, 2023 at 7 p.m. here in West Hollywood Park Public Meeting Room, Council Chambers. Thank you, everyone, and good night.